Hello, everybody.
This is file 24-02268 SC, JDAC Enterprises, LLC, Jeffrey Stevenson, plaintiff, Todd Shepard, defendant. Prior to beginning the hearing, I want to make sure that both sides understand that by being in small claims, you waive certain rights. You waive the right to be represented by an attorney. Excuse me. You waive the right to try the case to a jury. You waive the right to recover more than $7,000, and you waive the right to appeal the decision of the judge. If you stay in small claims, those rights are waived. If you don't want to waive those rights, this matter would proceed to the general jurisdiction. Mr. Stevenson, is it your intention to stay in small claims?
Yes, it is.
Okay, and are you also the principal person in JDAC?
Yes, I am.
Okay. And Mr. Shepard, is it your intention to stay in small claims?
Yes, it is.
And I would ask you to raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
I do.
Okay, thank you. The way we're going to do this is I'm going to ask a series of questions back and forth in no particular order. If I direct a question to you, I would ask you to answer it. If the question goes to another person, I'd ask you to let them answer it. When I'm done asking the questions that I think I need the answers to, I'll then go to the plaintiff, and the plaintiff will have the opportunity to present either testimony or documents that he thinks he needs to complete his case. When that's done, the defense has the same opportunity to complete their defense with additional testimony or documents as they see fit. If the defense brings up something new, the plaintiff would have the opportunity to respond to that which was brought up new. And after that, it's back to me and I'll issue a judgment. Mr. Shepard, I'm going to ask you the first question. And that question is that you have been sued for $1,607.22. Is there any portion of that that you acknowledge you owe?
Zero, Your Honor.
Mr. Stevenson, how did you get to the number 1607.22?
The amount was, if I remember correctly, $858 is what I invoiced for. With there was 1.5% per month for past due of a contract that Mr. Shepard signed. And then there were some small incidental, I had to have the Spring Hill Police Department submit the documents to them to bring them to small claims, and we tried another avenue earlier to that, so there were some costs associated with that, but that was rather small in the grand scheme.
Yeah, I'm showing a $50 filing fee, $10 certified mail fee, and an officer fee of $52.
That's correct.
That's it?
That's it from that. Yes, and the initial was $858, if I remember correctly, and the rest is interest as it went back to 2021.
Okay, can I see the document that you referenced?
Which
as to the invoice? This is an invoice addressed to Todd Shepard bearing the date 07/01/2021. Mr. Shepard, at some point in time, did you live at that address?
I did, and he did perform the work.
Okay, now as I'm looking at the invoice, I'm going to read what it says for activity. Water damage mitigation, content manipulation, packaging of retained contents in boxes, bagging up of items that were thrown out. Work performed was for contents only and did not include any charges for water mitigation. And that's the $858.71. Payments can be made via check made out to. If you preferred to pay with a credit card at 3%. Was there a contract, Mr. Stevenson, that was signed prior to?
Yes, June 24th. It's what we call a work authorization.
This is a 3-page document that bears the date, 6/24/2021. And The description of event is handwritten and reads, contents repackaged after water loss. Items that are dry will be repackaged cardboard. Items wet will be held back for disposition. Wood furniture will be placed on blocks while the area is being dried. The second page is verbiage as to what they do and don't do, and all that's contract terms and conditions. There's a number of not applicables listed. Payment. If payment is made directly to the client by the insurance company, it shall be endorsed over to the company within 3 working days. Any and all charges for services not reimbursed by insurance company, deductible, excess costs, etc., are the sole responsibility of the client and are to be paid upon the completion of the work. And Mr. Shepard, I'm going to try to show you the last page, and it appears to be dated 6/24/21. Are you able to see that page, sir?
I am. I can't read the written word, but I see my signature at the bottom, sir.
You do see your signature at the bottom.
I do. Yeah, absolutely.
At the beginning of this hearing, I asked you if you acknowledged that you owe the plaintiff anything,
Yes, sir.
and you said no.
I did.
Okay. What is the basis for your statement that, first of all, I'm going to ask you, has this bill been paid?
It has not been paid, sir.
Okay. How come?
I was the tenant of one Miss Elise Applebaum. It was her house. Her sub pump failed. I notified the owner, Elise. She hired remediation to come fix it. It was her obligation to pay for remediation. This bill should go to Miss Applebaum 100%. I lived
Why?
in the house, sir.
We didn't hire
Why?
them.
You signed the contract, sir.
We
I
didn't.
signed it as an agent of hers to get the work done, sir.
There was nothing on this bill that deals with the various steps that would be taken that would be germane to the building. What I'm reading in the description of event is contents. Contents repackaged after water loss. There was no billing for cutting out drywall, bringing in fans to dry stuff out, bringing in dehumidifiers to dry it out, to install sump pumps to take the water out. This is all just dealing with the stuff that was in the house. And it's my impression, and correct me if I'm wrong, was the stuff that they worked with your property.
It was my property, but due to the failure of the house itself, which I spoke to Miss Applebaum about and said, we flooded and I lost the majority of the contents of my basement. She called out remediation. It is my belief that had there never been a flood, I would not have needed it. But due to the poor equipment in the basement, it caused me to lose a lot of my property. So yeah, it is my belief that she should have paid for this because it was her domicile.
And she hired them. We didn't hire them.
Yeah, you did. Her signature isn't on this document.
I understand that.
If there was anything done by the plaintiff to deal with the flood and the damage to the building, that's clearly the landlord's responsibility. By perhaps contract theory, Applebaum should have paid your bill.
Mhm.
But I'm looking at a contract that bears your signature. The client information is you. There's no Applebaum on this at all. Now, it's my impression or guess that the plaintiff also did work there that he billed Applebaum for. And I should note, because you can't see him, that he's nodding affirmatively.
He did all of the remediation. Absolutely.
But this description of event is very clearly limited. The event as it is defined is limited to your stuff. And they did repackage some of your stuff, right?
He did, absolutely.
We didn't hire them.
Man, you might not have called them, but this is a contract that bears the signature that you
Well,
can see.
we've been renting for decades. And when we've had a problem, the landlord hires someone and we always have to sign because they're not at the property. We had no idea. If we knew we were going to be charged this, we would have done it ourselves. She was really wonderful and said, oh, I'm sending people out to take care of everything and then I'll fix the sub pump. We were in no position to pay that. We've had a horrible few years and we had no idea that we were going to be charged for this. And we have never gotten a bill ever from a property after a landlord's hired someone. And we've always signed for work. I just signed for a plumber a few weeks ago where we are now. So we had no idea that we were going to be getting a large bill.
I'm going to read you the last sentence on the last page, where it is authorization. As the client, I understand the work and accept responsibility to the company for services rendered. By signing below, I agree for the company to begin work and agree to all above terms and conditions. And the terms and conditions involve payment, involve 1.5% per month on the unpaid balance.
Well, what was also confusing about this situation was when we left the house, when we moved, she told us it was fine. We were moving because she wanted to sell the house. And then after we moved, her brother sent us a very threatening letter because he's a lawyer saying we would not be getting our deposit back and all these things. So we assumed that the same thing happened with this company because they have a history of not paying people back for things. And we just feel, I mean, my thought was maybe we were just the easy target because she had a brother who's a lawyer trying to get out of paying for things. If we knew that we actually owed that money, we would have paid it. And if we knew we had to hire them, we couldn't afford to pay that at that time. And we've had a really hard few years and we would have never hired them in the first place. She gave us the impression that she was taking care of everything and she felt terrible that she hadn't replaced the sub pump. So we thought everything was taken care of. And then we assumed after when they started calling us for payments, we said, please go to them. We did not hire you guys. And again, I guess it is confusing when you rent because we're constantly signing off on work done on homes. We had no idea that we would suddenly be getting a bill. And we would have had to figure out, we would have had people come help us clean that up. But we thought she was being kind and helping clean up because we lost so many of our things. And this was 4 years ago. And to get this bill now and have an officer come to our house was really upsetting. I just didn't, and we can't afford this right now. We've had a very difficult year. I can't work from an injury. We have kids trying to go to college. It's
Tammy,
just,
hold on.
okay, sorry. It's just very upsetting.
I know. So,
I understand it's
Your Honor,
upsetting.
and I signed it in, to be honest, I signed it in good faith because he did the work. And I signed it in good faith because I knew that
Good faith was that you were going to pay him.
the good
That's
faith
what the
was that the
document
payment
says.
would be made, but the payment would be made by the landlord who owns the house that the damage was taken from. The damage was incurred because of the failure of the sub pump. That was her house.
You might have an action against the landlord. I can't
Her
speak
brother's
to
a
that.
lawyer. We'll never, the system doesn't work for people if you don't have a lot of money.
It's okay.
I'm sorry, I'm going to stop
Small
talking.
claims doesn't cost anything.
Her brother's a lawyer. They already kept our $5,000 security deposit. So the whole thing was just very frustrating. And then to lose half of our things in that flood, and now to have this come back at us 4 years later, I don't understand that either. Why is this? And then that's kind of a joke too. It's double the price. But again, we wouldn't have hired them if we knew we were getting charged. She called and hired the company. We signed off on everything.
And
Because
then
she was in Florida.
And then to tack on the usury charges. When I thought,
History is about 25%. This is 18.
oh, okay, it's 18%, but knowing that it should have gone to Applebaum and not myself. So I thought it had been taken care of, Your Honor. I would have.
I don't know why you would think that, sir, when the document says what it says. I didn't make up the document. Mr. Stevenson didn't just come up with it today. This bears your signature on the 24th day of June, 2021.
And I didn't hire him, to be honest. I did not. He came out because Applebaum had him come out. He cleaned up because Applebaum had him cleaned up. He came out and fixed what he did I'm under the presumption that it is all based on that contract. I signed off that he did the work. Did I look through all the minutia? I did not. But this is, to me, this falls under the landlord.
You might well be right that the landlord owes you for it, but I have to tell you, sir, that this document is signed by you and it provides that you would pay. If you signed a document that you didn't read, that's not something the plaintiff can deal with. But the bottom line is, it says what it says, and they did the work. And this isn't work they did to the house. This is work that they did with your material, your stuff.
Yeah, but
She told us
without A, we would have never gotten to B, right? If the house didn't fail due to the sub pump, this wouldn't have never happened. Therefore, it was due to the house that caused.
That doesn't
the
change the
damage.
fact that you signed saying you'd pay for it.
Okay.
she told us that she was gonna, don't worry about it, I'll take care of
Now,
everything.
that's not between you and this plaintiff, that's between you and Applebaum.
Did the plaintiff send this to Applebaum to be paid?
The question was, did you ever send this bill to the landlord to be paid?
Yes, so
Okay.
just for clarification, I did receive the call from Ms. Guerrero asking us to come out, and she gave us Mr. Shepherd's phone number and set up the appointment. We did the exact same thing with her as we did with Mr. Shepherd. We had separate work authorizations. Hers was for the structure of the house, drawing that out and so on. His was for the contents. We invoiced her on July 3rd, and we received money shortly thereafter. In my email that I sent on July 3rd, I highlighted to her that she had told me that Mr. Shepherd was a tenant. And typically in the line of work I'm in, when you have a tenant, the tenants are almost always responsible for the contents, and the homeowner is responsible for the structure. And they're supposed to be self-insured on their contents and so on, regardless of what the reason was for the damage. So that's why I made sure that we had 2 work authorizations. On July 3rd, when I sent her the invoice, I said, I'm very concerned about getting paid by Mr. Shepherd. You informed me, and he signed a work authorization. You informed me that he's responsible for the contents, and that you had that conversation with him. I was not privy to that conversation, but she went through all that with me. So we proceeded, but yet shortly after sending an invoice to Mr. Shepherd, I immediately was concerned that I'm caught in the middle. And I even said that to her. I feel like I'm caught in the middle on this. She said she wrote back, I tried to reach him. He's not calling me back. That happened to be a holiday. However, it was July 4th. Never heard anything after that. I did ask for clarification coming into this in small claims. And she wrote to me, I asked, can you please state for the court what your position is on this? And she said, this is Elise Guerrero. At the time of June 2021, I had a tenant, Mr. Todd Shepherd, lease my unfurnished home. She provides the address. I hired Jeff Stevenson to restore my basement of water damage, of which was paid in full and on time. Mr. Shepherd was responsible for any work done, as well as costs associated with his own personal contents in the basement of this property. Elise Guerrero, and that was January 10th, 2025.
Well, what her statement says to her lack of responsibility isn't anything that we need to address because
Okay,
she's not.
understand.
Mr. Shepherd, did you have renter's insurance?
And to be honest, I can't recall. We usually do have renter's insurance. Jamie, I don't recall if we did in this. I know we do right now, but I can't recall if we did at the time.
Because whether it's a rental or a condo, there's basically 2 sets of insurance policies. One is for the building and the structures within the building, and the other is for the contents and anything inside the paint. In a condo, it's inside the paint, and and a rental is probably different. But the bottom line is that the insurance companies sell two different policies. One for the stuff that's in the building and one for the building. Now, if, for example, there's a leak and the carpet is damaged or drywall is damaged, those would be two different things, because the drywall is part of the building and the carpet or rugs on the ground could be the property of the tenant. So I understand what you're saying when you say that Mr. Stevenson's people came out because they were directed to by the owner of the property, but their contract with the owner had to do with the actual structure of the building, and their contract with you had to do with the contents. And again, I'm not speaking to whether or not you have a cause of action against the landlord, but it isn't the plaintiff's obligation to make sure that you understand that when he's dealing with your stuff, it's going to be paid for by you over and above a contract, a 3-page contract that specifies that. It's preformed, it's printed, and many of the things, several of the paragraphs are not applicable, but the payment one is, and you signed it. You agreed to pay.
So the verbal contract I had with Elise that she was taking care of everything doesn't hold water here, right? Because it has nothing to do
It
with
has
it.
nothing to do with your contract with the plaintiff.
Oh, it's unfortunate, but I understand what you're saying. Because I feel as much as this gentleman, Mr. Stevenson, feels in the middle, so do I. I'm the one who took the hit on it. I felt that it was taken care of. It was not my intent to put this person in the rears in any way. However, I felt that the allegation and the understanding between Miss Elise and myself was that due to the problem, she was taking care of it. That's why we're here. But if that has no bearing on your judgment,
Because it's between you and Mr. Stevenson. Statute of limitations on a contract is 6 years. So we're 2 years from the end of it. So we're sitting there in the middle third, the end of the middle segment, but it's still within the law, and he did what he said he was going to do.
oh, he did
Indicated.
absolutely, sir. He did the work. It's just Applebaum should have paid for the work. That's all.
I'm not disagreeing with
I know.
you. It's not-
I
I'm
know.
not disagreeing, but the bottom line here is that I think you owe him the money. The interest is stated in writing in the contract. It is not usury.
I didn't even know this was still going on. So to have all these years of interest is hard too.
Well, you've had the money all that time. So it's 6 of one, half dozen of the other.
That's debatable because I didn't have the money.
We almost moved. We almost moved into our car 4 months ago. This is the horrific. I was injured. I can't work. I mean, this is just horrific to add on to everything. And it's so funny. We finally felt like we're getting somewhere now. And then this shows up. I just feel like, so we don't have, I don't know if we can pay it in installments of $50 a month or something. I don't know what to do. We can't do any more loan. We can't.
Do you want to make an offer of installment payments?
Well,
I don't know what to do.
You're
We
going
don't
to tell
have
us to
the-
pay
We
him.
can build that. We can build that into the judgment if it's agreeable to both sides.
Yeah, I feel that
Stevenson with $50 a month.
That's unacceptable. It's gotta be.
Never
No.
stops.
No,
I was
The-
severely injured by a vaccine and I almost died. And it was going on during this whole thing. And they have the money. She's very wealthy. And she said, I'll take care of it.
She's not a party to this lawsuit, ma'am.
I know, I'm going to stop now. Go ahead and just stop.
so we did try in the end of 2022, after I gave up trying to collect, we did hire an independent company, a collection agency, to try to go after it. And after 4 months, I reviewed them from that. Primarily because I was told, and again, I had no contact with Mr. Shepherd at the time, but I was told that the discussions were starting to get a little aggressive. And so I pulled the person back. I have my reasons for why I did it now. We still have the interest on the money. If we get into payments, it's still the same interest that's there.
Okay. When the concept of $50 a month was put into the air, you rejected it. Is there a monthly payment that you would accept?
$250 a month.
Okay. Mr. Shepherd, I don't know if you could hear what Mr. Stevenson said, but he said he'd accept payments of $250 a month. If you don't want to commit to $250 a month, you're under no obligation to do so, and the judgment will enter, and then he's up. Then it would be collected by however it's going to get collected. But the bottom line here is, if you want to agree to a payment of $250 a month, then you would not be subject to collection procedures as long as you were current with that. If you don't want to, that's, if you can't do it, you can't do it. You don't want to agree to something you don't think you can do.
But if we don't, I'm trying to figure out how to pay him. So if it's not entered into judgment.
No, I'm saying it would be.
I know, but if it wasn't
It would be
entered
an
in,
installment judgment.
I'm sorry, if I wasn't entering it as 250 and I can't pay him in full, is it just between he and I as to how I can commit to paying him back? Or how does the judgment look, the settlement? Is it, I have to pay the whatever X amount it is in full? And if I don't,
if you have a judgment entered against you, it's your obligation to pay. If the defendant doesn't pay, then there's certain collection steps that a plaintiff can take. There's certain steps that can be done to attempt to collect on the judgment. Some of those are successful, some not. And one of the benefits of an installment judgment, that terms and conditions are agreed to by the parties, is that neither side has to get involved with the collection process. It's just done. And typically the plaintiff wants his money now, the defendant wants to pay later. That's nothing unusual about that. But the bottom line here is that both can be spared the grief of the collection process. It's not going to be easy. The collection process is never easy. And it can be irritating as well. But the bottom line here is I don't want you to commit to something that you don't think you can do.
do I have Mr. Stevenson's address to send money to, I guess is.
We can make sure that that's there, but before
I'm not
we
going
get
to
down
commit
to
to, I'm not going to commit to the 250 the gentleman asked for. I would just ask that I find a way to get money to him. And I just don't see anything on the documents that I have. Oh, I do.
you have a copy of the complaint that
I
has
do.
his address.
Yes, I do. It's his business address, if that's okay with Mr. Stevenson. Sure. Okay.
That's his address. Now, Mr. Stevenson, the number you came up with was 1,650 something, I believe, 160722. Was that inclusive of any of the costs?
That has the interest as well as the separate fees of mailings and things like that.
Okay, so we're going to take $112 off and then add it in. It's going to come up net. But the 160722, we take off 102. That leaves 1505.22, and then we add costs of 102, bring us right back to 1607. So a judgment will enter in the amount of $1,622. This date, it will be mailed to both sides. When the judgment is mailed, they include some verbiage as to what people can do with judgments from either end, and that'll do it.
1622.
1607.22. Verify that again. 1607.22
Thank you.
is the total judgment. Judgment is 1505. Costs are 102. The total is 1607. 22.
Still gonna protest the interest, but I don't think it's gonna matter.
It's not usury,
I know.
and it is in writing in the document.
I understand. I
There are
understand.
companies that will add this without putting it in the document, and that doesn't fly in court.
Okay.
But this is all stated out there in black and white. Or in blue and white, whichever way you want to look at it, but it's here. So the judgment will be mailed to both sides.
Thank you.
Thank you.
Be safe, be well, sleep sweet, and much love.